a declination of that kind of investment system to what we call the SMAD, the equivalent of VOD. So even digital media will soon be a source of money for production, and being a source of money for production, it will be also a source of money of that copyright market. And at the other end, you have the publishers and the producers, and producers are looking for more and more adaptation, while publishers are looking to just increase the revenue they can have on one kind of novel. And the whole system, partly due to that public subvention and public monies, is for the time being working quite well.
I just want to ask a question to the game industry, to Malte Behrmann. If you could wish something, if you have a vision about what should happen to support the game industry as the film or other media industries are supported by government or regulations or funding, I mean subsidies, how would this vision look like?
Yeah, this is interesting. I think that nobody wants to take away the support system from the film industry. That is very important to say. I think that the French system, where you have a certain amount of support for the beginning, new prototypes, and then a tax credit for the large productions, is one of the best models in the world for the games industry already. You have other models which are in other countries like Canada, which are massively supporting the whole production with tax breaks up to 50% of the whole production budget. We have to understand that these tax breaks would never exist under German law, because we don't understand that they actually get 50% back from government. Nevertheless, whether they make a profit or not with their production, because under German tax law, a tax break is always linked only to the profit, but this is not the case in these countries. In these countries, if you get 50% of the production budget, you get 50% of the production budget, even when you don't make a profit. So that is something which is already very good. I think direct support systems are preferable to indirect systems where you involve VCs or other private sources, and then you try to do some kind of a mixture, because then you have, as he explained, to involve so many players, like insurance companies, additional lawyers, other banks, and so on, that at the end of the day, a lot of people earn a lot of money, not necessarily those who make the game or the film. So I think that these models are preferential. I don't know if this is an answer to your question, but
it is,
at least
yes.
I have made a comment.
Yes, it is an answer. And could you please, Lawrence, describe a little bit the political and economical influences on the legislation concerning media rights in the UK? And the second question I would ask you is, would a European market for media rights, or with what characteristic would a European market be wishful or a vision for you?
Well, sorry, what was the first question again?
Sorry?
What was the first question again? I got the second one.
Please comment the political and the economical influences of the legislation.
The political and economic influences are again more in the area that I'm not so qualified, unfortunately, to speak on, which is of course the area of whether the legislation is strong enough against piracy measures and people illegally downloading. That, of course, has been the same debate, I think, in every country. It's not an area I specialize in. I'm aware that our law is toughening in that regard. There are difficulties in practice in pursuing large numbers of people for copyright infringement just on a practical daily basis. Some law firms have experienced some difficulties, let's say. There is an instance in the UK of the Consumers Association called which has been around for a long period of time, which is very strong, which has been defending, as it were, the interests of ordinary people against what is perceived to be the heavy hand of the fat, rich media companies, etc. And of course, the ISPs are in the middle of that. So that's a very live debate. There's not really a debate in the transactional film industry as such at the moment, not around rights anyway. There's always a debate about the whole topic of subsidy and support. And you may be aware that we had a change about 4 years ago in how government tax support is provided for film in the UK to more of a tax rebate system with more simplicity, hopefully. And that was a good debate, and also what I think was good about it was that practitioners were asked by the legislators for their views before the legislation was enacted. Because so often, I think, in the past, there has been a disconnect between civil servants and policymakers and people like myself on a day-by-day basis who need to implement this legislation. And I think that has led, well, it's undoubtedly led some real issues in the past. I think I'm right in saying that when we had the sale and leaseback, which was quite a good product in terms of producing cash for the industry, that the government never intended it in the UK to be a support for the TV industry, because the UK TV industry is a big and powerful industry that on the whole does not need government support, whereas the film industry has had government support in the UK throughout most of the last century. It isn't a recent thing. There was some form of support even pre-war in the UK going back to the 1920s and 1930s. In terms of an ideal market, I mean, obviously in an ideal world, there would be further harmonization of national laws so that somebody in one part of the EU would be operating under the same copyright and rights legislation as under another part of the EU. We've had some degree of harmonization a few years ago in terms of copyright periods. One time, there were different copyright periods applicable to different works in different territories. That was harmonized. Also, some degree of harmonization in relation to ownership. The UK has always taken an economic view of copyright as being a property right rather than a creative right. And as part of the harmonization process back in the mid-90s, we did adopt to a certain extent, the more creative view that the director of a film should also be seen as a copyright owner of that film. The way that we tend to do these things in the UK, though, is to, rather like with the introduction of moral rights, which we didn't have, is to say, okay, we'll introduce those, but we'll immediately allow the powerful players in our business to disregard them. So, for example, our moral rights are waivable, and routinely creators are asked to waive those rights in their contracts.
Our moral rights are not
which I know can't happen in France.
And will never be.
So we do really still, on a policy basis, I think, conceive of copyright as a property right protecting property and money interests.
Well, I think it's, as always, it's a question of money. We are speaking of an industry which is an industry of prototype. I'm speaking of television production and film production. It's an industry of prototype. So it's a question of money to make the prototype, and this is why our legislation is trying to moving forward. At the time, the French government thought about doing an equivalent of the UK sale and leaseback, and then when the French government realized that at the end of the day, most of the money went to the intermediaries and not to the producers, they decided that that was not an appropriate system. So this is why they issued the tax credit, the first tax credit, and 2 years ago what we call the TRIP, the tax rebate on international production, which now welcomes foreign producer to do their films in France, the equivalent of the system you have in Germany. So on the one hand, it's the money to make the prototype, and on the other hand, it's the money to try not to lose too much money due to the piracy on the products. And this is why there was a huge and heavy discussion on the Adopi law project that was voted a year ago, because they realized that what happened to music on the internet was about to happen to films and TV series, and they couldn't allow it because of that same question of money. So Adobe now is structured. We have that, it's another independent authority, as the one I mentioned earlier, the CSA. And Adobe, a week ago, has implemented its first practice of notification to the wrong user. But we all have to remember that the whole Adobe system is grounded on this following idea, is that when a web user is receiving such a notification, theoretically, most of them will stop to wrongly hacked, but that is still, I think, have to be demonstrated.
I want to make a remark to this, his comment on the waiver of moral rights, because that, I think it's I would be very interested how you see this. In Germany, of course, you are not allowed to waive moral rights, but you find it in every contract, all the time. And actually, it depends whom I am consulting, but when I consult the creative side or the developer, I don't say anything, because I think that it's so obvious that it is illegal and that it is. But why should we insist on having not a waiver of moral rights being in the contract, in the agreement, when it's obviously you can go to any court in Germany and just say, look at this is at any time. It's just a complication with the other side in the daily practice. So I personally, unless there's a specific reason why I should do it, I just leave it as it is, because at least in the games industry, there's a habit that people believe for some reason that US contracts are more valuable than German contracts. So they very often, they just get US contracts from the internet and then they download it and then they put it under German law. And then you get these contracts to look at from the developer side, and you just look at this and say, yeah, all these clauses are all illegal in Germany. But why should I now say this to this other person? I mean, in the case of a real dispute, we could always go to court and say all these clauses are illegal anyway. But it's not. In some cases, it is necessary that when, for example, when you warrant something or something, you have to take care. But I mean, if this is all taken care of, then there's sometimes you just leave it as it is, and it is illegal, and everybody makes it anyway. And probably those people who don't have a lawyer believe that it's actually in the contract. What's written in the contract is true. But believe me, most of these creative contracts, at least in Germany, are in certain points just not according to the German copyright law. And it's just very funny because everybody does it anyway.
Well, in France, you wouldn't have to write it down in any agreements, author agreements or copyright agreements as far as film is are concerned, because it's in the law. So, and because it's in the law, as you pointed out, if a French author would be in a position to sign an author agreement with a moral right waiver clause, it will be, of course, overruled by any French court. And there's two interesting cases. The first one is a very famous one about an American film named Asphalt Jungle from John Huston. And the American had decided some years ago to make a colorized version of that black and white film. So what John Huston's heirs did, that they came to the French court because they heard that the film was going to be aired on a private channel, and they said, well, your moral rights is universal, and I'm claiming the protection of moral rights being the heir of John Huston. This film was shot in black and white for artistical reason, not only for technical reason of the time, and they won.